Hey everyone, Rob Ryder, November 11th, 2012. 70 degrees in Michigan on the 11th of November. Unbelievable. I'm going to take it. So we've been talking about the court of equity, chancery, what is equity, what it is not, legal title, equitable title, on and on and on. And we're going to see what we can do with this stuff today. And if you can donate, please do. There's my address and my PayPal account. So, without any further ado, let's go kick some owl ass. Because we're going to find out how to get us a piece of paper that has one of these on it. The seal of the Michigan Supreme Court, Lansing. I wonder if it's, what's it mean? It's got a hole here, right? Got two arrows coming together with a gap. That's interesting. Well, it means something to somebody. But what is this? And how can we use it? Well, what we're going to see is it's a thing called a subpoena. And I don't know why we're not using this thing. Let's see if we can. So, what is a subpoena? It's an order directed to an individual, so it's in personam, commanding him to appear in court on a certain day to testify or produce documents in a pending lawsuit. A process to cause a witness to appear and give testimony, command him to lay aside all pretenses and excuses and appear before the court or magistrate therein named at a time therein mentioned to testify for the party named under a penalty therein mentioned. This is usually called a subpoena ad testicatum. On proof of service, a subpoena upon the witness and that he is material, an attachment may be issued against him for contempt if he neglects to attend as commanded. They put you in contempt of court for not answering a subpoena. And once you know it, it's a chancery practice, a mandatory writ or process directed to require one or more persons to appear. And we can thank John Waltman, the Bishop of Salisbury. Gotta love them Catholics. They gave us a subpoena. What can you do with it? Well, this is out of a Michigan Criminal Code. It says the clerk of any county in which an indictment shall be found upon the application of the defendant and without requiring any fees shall issue subpoenas as well during and sitting of any court as invocation for such witness as defendant may require, whether residing in or out of the county. Bingo. If you want to get these people to come in and tell the truth, you got to subpoena them. And if they put an indictment against you, the clerk will issue subpoenas for you for free. Disobedience of any subpoena issued pursuant to the foregoing provisions shall be punished same manner upon like proceedings provided in law in other cases. They can put you in jail for it. What can you use them for? Well, removals of office. The Attorney General or prosecuting attorney may issue subpoenas. So who can? Well, the Attorney General can, and so can a prosecuting attorney. The magistrate may issue subpoenas for witnesses returnable immediately at any time or place prescribed in the subpoena. So a magistrate may issue subpoenas for witnesses returnable immediately, right? Which could mean they have to come and answer right now if it's immediate, right? Or at time and place prescribed in the subpoena. They don't get to think about it very long. Public records inspections, use, copy removal. No book, record, file shall be removed from the office of the custodian thereof except by the order of a judge of any court of competent jurisdiction or in response to subpoenas for testimony, or I think that's for testimony, issued therein. So a lot of people have tried to get their certificate of live birth or the original record from the county, and they said, well, that's going to take I'll take court order. The district court has same power to issue warrants, subpoenas, and subpoena witnesses. So the district court has the power to issue them. All right. What do we got here? Transfer of property by third party. When a third party having in his or its possession property or monies belonging to the judgment debtor who is indebted to the judgment debtor is subpoenaed. Right? So what this is saying is you can subpoena the bank. You can subpoena the title company. They're in possession of your property or money. Somebody's holding the title deed. Somebody's holding your securities. So you can subpoena them, and they have to bring in the records and tell you why you owe the money. Right? Everybody wants to know how to handle a foreclosure. Well, fucking subpoena them. So we'll get into how to exactly do that, but, that's what we're going to use. We're going to use this damn piece of paper right here. Because if you look at this thing, right, you can put it in a district, circuit, or probate. As we're going to find out as we go on here, we're going to probate. Court address. You can check the box for the people of the state of Michigan. That would be the prosecutor. Or you could check this box and put you in here. In probate, who the defendants are and what the charge is. Well, what would the charge be? It would be, what maximum of equity maybe they've broken. Could be a penal code violation. Lots of things. And so, in the name of the people of the state of Michigan, too, whoever this is, you are ordered, right? You are ordered to appear personally at the time and place stated below, to testify at a trial, to produce, permit, inspection, or copy of the following items, whatever it is you want to see. Testify as to your assets and bring with you the items listed in 3 above. Right? So one of the things we could be asking for is an accounting of our escrow account. And, and then the person requesting the petition or the subpoena is you. It's coming from the Supreme Court. Failure to obey the subpoena or appear at stated time and place may subject you to penalty for contempt of court. Well, they put you in jail for contempt of court. That's what they're telling them. So it's a powerful piece of paper. Powerful, powerful, powerful. And so if you were to go search on the word subpoena in your, we got Michigan compiled laws here, whatever you call yours, you're going to find out that all these different committees, I want to make sure that's right. I want to say committee. What do they call the, not a committee. Commission, like county commissioners, right? There's all sorts of commissions that have the power to subpoena, and the power to subpoena is a power of the chancery. It's it's an equitable relief, and so you're having equity used against you all the time because, as we'll see, hopefully, what they have is an equitable mortgage. They don't have a legal mortgage, they have an equitable mortgage. They have it by fraud, but that's what they have. So they go to equity to try to get relief, but they didn't come with clean hands. This is the wonderful thing, right? The attorney in a foreclosure is not representing the bank. You don't have a contract with the bank. The reason I say this is just because what people have told me, that one guy had an opportunity to have a bank under deposition, and he asked them if they were the plaintiff, and they said, no, we're a witness. Right? That's what the bank said, and I'm sure they're not lying. They're not the ones trying to take your house. This attorney is. With who knows who in the background, but it's not the bank, but they're doing it in the name of the bank, and they don't have a frickin' contract with the bank, so it's misrepresentation. Well, that's frickin' fraud, man. They put you in jail for that. So we subpoena to see the contract between the bank and the guy that says he's representing them. If he doesn't have it, then it's misrepresentation. And there's already a remedy built in for that. Right? He's going back to the fleet. He's going to pay the costs. You're going to get damages because, a court of chancery isn't a court of law. When they merge the two forms of law, well, they didn't actually merge them. The administration of them, they're two separate forms of law. But still, they pass these legislature to allow court of chancery to give damages and the courts of law to give equity in certain things. So every court has an ability to give equity. And commissions are just one. So again, if you were just to search on the word subpoena, you're going to find out how they're used all over the place against you, but what we can do now to make them to be used for us. For instance, the Administrative Procedure Act, an agency authorized by statute to issue subpoenas when a written request is made by a party in a contested case. What more is there? If there's an agency over something and you're having a controversy with them, well, then you can write a written request to get a subpoena and make them prove that you owe the tax or whatever it is. All right. So again, I don't know what all these can. I know this can be used for everything. I'm gonna put it that way. This can be used for everything we need to do. I just don't know how each one would be written yet. But the idea is, if you want to get testimony, because testimony is under oath, and production of the evidence, including the books, the records, correspondence, documents, right? You need to use a subpoena. Oh, so there was a creation of the State Office of Administrative Hearings, Type 1 agency within Department of Labor, Economic Growth, Duty, Services, Hearings. So these are just things about little pieces I found that really don't fit into exactly any one thing. It's just, apparently, there's an agency that can do it, and it's called the State Office of Administrative Hearings. Looks like to me. Certificates for part paid state land. Whenever any part paid certificate of primary school or other land shall be lost, destroyed, the owner of the land hereunder such certificate may apply as a court of the county for which the land is situated in order that duplicate certificates may be issued. I didn't know there's a thing called part paid state land, right? So it's just something I want to go look into to find out about having the certificates issued. And what else was there? Oh, and then we have a protective committee. All this stuff here is for Michigan, right? It's called the Public Trust Commission. I didn't know there was such a thing. The Public Trust Commission, and they can subpoena. Ooh, Savings Bank Act, they can subpoena that too. Circuit Court subpoena to appear in the Savings Bank Act. So these were acts I want to go back and look at, but they're just different things that subpoenas are used in. Insurance, unfair methods of competition or deception, right? If you got an insurance claim and they're not paying it, well, you want to subpoena them. I don't know exactly what to ask them yet, but there's a commission that you can write a complaint to, and then they're going to subpoena the insurance company. So courts of record powers, they can issue process of subpoena. So a subpoena is a process of its own. It's not a common law process. It's a process in equity. To administer oaths in any matter or cause or in any other cause, it may be necessary to exercise powers and duties of such courts. So the only place oaths and all these other things are used is in the court of equity, under chancery. And the authority of a municipal court judge to issue subpoenas. Lots of people can issue subpoenas, was the point of all that. So they can be used for lots of things. And now how do you get a subpoena? Well, I think we have to do a petition as part of getting a subpoena. So who do we want to petition? Well, we're going to find out who has the power and where we want to take our paperwork to. So, circuit court, jurisdiction and power. Circuit court has power and jurisdiction. Possessed by courts of record of common law, possessed by courts and judges in chancery. So it has power in both law and equity. It has exclusive jurisdiction in condemnation cases commenced under the Drain Code. Interesting thing about the Drain Code, right? In Lord Coke, where he lists all the different courts, one of them is called the Court of the Pipe. And when you read what it's about, it sounds like the Drain Code, like the Drain Commissioner. That's what they call him now, Drain Commissioner. He's the He's got a court called the Court of the Pipe. The circuit court has concurrent jurisdiction with probate, or the district court, or both, as provided in the plan of concurrent jurisdiction, except as the following matters. So, again, they pass legislation, let each chancery have some law, and law have some equity, except for a few things, and here's the one we want. The probate court has exclusive jurisdiction over trust and estate matters. Your all-cap letter name is the name of a landed estate. It's your property. Quit running from it. You know, no, you're not the name. It's your frickin' property, so tell them it is. And the probate court has exclusive jurisdiction. So we want to take our petitions to probate. And then, except as provided, district court has jurisdiction over small claims, civil infractions. Right? The thing about the estate and the trust is, a trust is an unexecuted use. And so it's when you sign a contract and it looks like there's only one signature on it, and that makes it a unilateral contract and it's not binding. It's like a gift because it hasn't been executed, and a trust is an unexecuted use. You've still given the paper to, you've transferred on paper legal title to something, to somebody. But they're supposed to sign it and give it back, or you don't have an agreement, and they never do. So a trust is an unexecuted use. So the probate court has exclusive jurisdiction over unexecuted uses. Any contract that only has your signature on it is an unexecuted use. And estate matters, and your all-capital letter name is your estate. All those accounts underneath it are your property, and we're going to go claim it as ours. Oh, amended probate court jurisdiction and power. Probate has power over, basically what the things I just talked about. The interesting thing here is the circuit court has exclusive jurisdiction and powers to issue here determine prerogative remedial writs. Okay, so the courts of law are the only ones who can issue like a habeas corpus, writ of mandamus, so forth and so on. That's what the circuit court does. But the Court of Chancery can issue a subpoena. So they have their own action, and we're going to use the subpoena. Removal of an action or proceeding to probate court upon motion of a party after a finding and order on the jurisdictional issue. Right? Well, probate has exclusive jurisdiction in estates. So, put in a motion that this is a matter about an estate and it has to be heard in probate. Petition, inventory, accounting, proof of claim, or proof of service. So this says on a petition, so forth. File with the probate court need not be verified, acknowledged, or made on oath if the person signing the instrument states immediately above the date and his signature, so immediately above the date and his signature, I declare under penalty of perjury on this, whatever day it was examined by me, and that the contents thereof are true to the best of my information, knowledge, and belief. The provision shall not apply to nominations by guardian minors. So you don't need to go that far. All right, so if you want to put a petition into probate, you don't need to do it under oath. You just need to fill out this little declaration. And a person who falsely executes files of probate court is involved in this action. An instrument containing declaration under penalty of perjury may be found guilty. Okay, well, it says it's just the best contents thereof are true to the best of my information, knowledge, and belief. Right? So now they got to call you a liar. Well, if you're going to call me a liar, you better show me the proof. And then I'm just mistaken. I made a mistake. Forgive me. Fees for bringing appeal, registering trust, or depositing will. Fees for bringing appeal. Again, this is probate. So, upon appeal from the probate court to the circuit court or court of appeals, a party bringing an appeal shall pay $25 fee to probate court registrar. Upon appeal from probate court Okay, to these other courts, the party bringing the appeal to probate shall pay $25 to the probate court register. So you can appeal a case that's happened before into the probate court. And you can make them, they'll issue a subpoena to make whoever the plaintiff was, whoever brought the charge and the original charge, come in and prove their claim. It doesn't matter when it happened. And that's why you use a subpoena, because if they can't come in and do it, well then immediately, if somebody's in jail, they were released. Upon registering a trust or depositing a will for safekeeping. See, I wonder if our trusts have not been registered. I don't know. Has the unexecuted use been registered? Has to have been. We know it's been registered. And if not, well then, if that's what needs to be done, we'll ask them. This is out of the Michigan Constitution. Hear and determine prerogative remedial writs. Okay, again, that's the circuit court. And we're not looking for prerogative or remedial writs. Those are writs of common law. So, this stuff in Michigan. Now, here's something from the state of Massachusetts. Complaints in equity. A plaintiff who seeks equitable relief must bring a civil action complaint seeking a judgment for the relief demanded. All complaints must be researched and drafted by the litigants, as there are no equity forms. There are no forms to fill out for equity. The civil action is commenced by mailing or delivering for filing with the Register of Probate a complaint and entry fee required by law. Okay? If you have a complaint in equity, which we do, and you're in Massachusetts, which Bob is, right? There are no equity forms, Bob. We just got to put a civil action in. Mailing or delivering or filing with the Register of Probate a complaint and entry fee required by law. And we can ask them for a subpoena to make the plaintiff bring in the information. So read this, Bob. Refer to Mass Civil Procedure Rule 10 regarding the appropriate form of pleadings. Because certain equity complaint filings require serving a citation in place of a summons. The defendant may answer by way of responsive pleading or a motion when permitted within 20 days after. Got 20 days to answer. Beautiful. This is a Yahoo article. Probate court handles legal matters governed by equity law. Probate court may also be referred to as a court of equity, court ordinary. That would be the bishop. Surrogate court, orphans court. Right, all these things are same jurisdiction in equity as a probate court. Massachusetts probate courts, equity jurisdiction. The probate and family court department shall have original and concurrent jurisdiction with the Supreme Judicial Court and the Superior Court Department of all cases and matters of equity cognizable under the general principles of equity jurisprudence. And with reference thereto shall be courts of general equity jurisdiction. Okay? Probate, equity, complaint, subpoena. Owl just had a bad day. Probate court shall also have jurisdiction concurrent with the Supreme Judicial and Superior Courts for all cases, matters which have equitable relief is sought relative to. If you want equity, you got to go to probate. If you're in Massachusetts, if you're anywhere, they have jurisdiction over your estate. Cases involving in any way the estate of a deceased person or the property of an absentee. An absentee you're just missing, whereof the receiver has been appointed under Chapter 200, the property for a person under guardianship or conservatorship. Right? We're absent. We're just absent. That's all we are. We haven't appeared. You can go claim your house if that's what you want to do. You can go claim your body, which is what I want to do. Claim the body, claim the entire estate, take it out of the hands of the owl. You can't spend it all anyways, and really that's not what it's for. But what it's going to do is reduce the world debt. Right? So then we'll appoint somebody to, now we will appoint an administrator, and we'll make him do his job. New Jersey courts, General Equity Division, civil cases in which monetary damages are not being sought, because that's what equity is. We're not looking for money. We're looking for justice, are heard in the Chancery Division, General Equity part of the Superior Court. They can't make it any plainer. And then here's the kind of things they do: mortgage foreclosures, cancellation of a mortgage. Well, that's what we're trying to do. Get a quiet title. Yeah, that'd be nice. Partition of property. Well, that's to split. I think that's to split the property in little pieces. We don't want that to happen. Enforcement of contractual obligations. You have a warranty deed, a sales contract with the grantor. You bought the property. You've acknowledged it. I want them now to finish the contract and give me the title. Specific enforcement of contracts. That's what we're looking for. And if they say there's a lien, well, then here's a subpoena. Bring it in and show it to me. And look at this. They even put the Gail, she's got her phone number. You can call her. The General Equity and Probate Division is located on the first floor of the old courthouse. There's the phone number for the judge. There was something interesting. Oh, okay. This equity court processes approximately 401 case a day, basically, is all this court's doing. Nobody's going there to ask for these things, is what they're telling you, but this is what they have the jurisdiction over, for God's sakes. Unbelievable. Probate court. It's also called circuit court. Got lots of names. Has to do with an estate or a trust. You're in the right place. Enforces the provisions of a valid will by issuing a grant of probate. Prevents malfeasance by executors and administrators of estates and provides for equitable distribution of the assets of the person who die intestate without a valid will. In contested matters, a probate court examines the authenticity of a will and decides who is to receive the deceased person's property. Look at your one of the forms we're going to look at shortly. In fact, let's just go look at it right now. Let's just do that. Which one was that? Application for informal probate. This is what you use with one of your family members' death certificates, in my opinion. The estate of them, who you are, what your relationship was, a death certificate, information, anybody else who'd be interested, yada, yada, yada. A venue is proper county because the decedent was domiciled in the county at the date of the death. So wherever they died, that's where they were. The decedent died intestate after exercising reasonable diligence. I am unaware of any unrevoked testamentary instrument relating to property located in the state defined in another MCL. Right? I think that we all died intestate. We don't have valid wills. They never have you do a valid will because they never sign anything. Right? A will would actually be a use. I'm going to leave it in the hands of George to take care of my family for me. I'm going to give George a legal title, and George is going to take care of my family if I die. Right? And disperse my property this way. So I think you use this form into probate with a deceased family member's death certificate, and that's how you release their estate to you. And it is simply called Application for Informal Probate and or Appointment of Personal Representatives. Now, we saw in Massachusetts they don't have any forms, right? So it doesn't matter. You would just use this information to make up an application. The circuit court can be petitioned by interested parties in an estate, such as when a beneficiary feels that the estate is being mishandled. The court has the authority to compel the executor to give an account of his actions. We can get an accounting of our estate. Not all jurisdictions have probate courts. In many places, probate functions are performed by the Chancery Court or another court of equity, right? When you find it, you are in the court of equity. The court of equity. Not one that has some equitable powers, one that has all the equitable powers. I think this is interesting. This is in Michigan. Birth registration required, filing record of birth, so forth. A record of birth for each live birth that occurs in this state shall be filed at the office of the local registrar not more than 5 days after the birth. Well, that's interesting because on my certificate of live birth, it was received by the local registrar 13 days after I was born. I think somebody made a mistake. Right? There's the defect in the paperwork that shows that I'm not alive. Could be. Whatever they're using to get us into this. New Jersey. New Jersey. Listen to this, New Jersey. Restoration and recovery of property upon reappearance of absentee. Jeepers, this sounds like it could have something to do with Cesta Cave V Act. If an estate or property has been received, recovered, taken into possession by any person by reason of declaration of death under the provision of this chapter, you've been presumed dead, lost at sea, whatever it is, and in any action or proceeding, it is thereafter proved that the person declared dead was alive at the time by you walking in and having an informal status hearing. Recovery or taking into possession the estate or property or its reasonable value at that time shall, except as otherwise provided by law, be restored to the person deprived thereof by reason of the declaration, or his heirs, devisees, personal representatives, other persons entitled thereto. He or they may also demand and recover the income, rents, profits therefrom during the time he was or they were deprived thereof. You get all your property back. Arizona, presumption of death for 5-year absence, restoration of estate recovered upon presumption. A person absenting himself from the place of his last domicile for 5 years successfully shall be presumed dead in any action wherein his death comes into question, unless proof is made that he is alive within that time, except as otherwise provided in this section. In a subsequent action, the person presumed under Section A to be dead is proved to be living. The estate shall be restored to him. He may, moreover, demand and recover the rents, profits, estates during the time he was deprived thereof, with interest. You just got to give him an application, for God's sakes. Recording the bonds. Okay, you want to know where the bonds are, these court cases? That it shall be the duty of the county clerk. Didn't say the clerk of the court, register of deeds. It said the frickin' county clerk. In all cases where bonds and other obligations are filed in any civil case, either on the law or chancery side of the court. Guess what? The court's got two different sides. You got to ask them for both sides to record the bond or other obligation in a book. So the bonds are recorded in a book with the county clerk, not with the clerk of the court. That's why you're not seeing the entire record. You're going to the court record to get it. You're not going to the county court, the county clerk, and asking for the frickin' bonds. Oh, so anyways, Michigan. Estate and protected individuals code. My favorite. Evidence of death or status. A certified or authenticated. And so what's the difference between certified and authenticated? You took the certified copy and had the person who certified it authenticated. Of a death certificate purporting to be issued by the official or agency of the place where the death purportedly occurred is prima facie evidence in the decedent's identity and the fact, place, date, time of the decedent's death. A certified or authenticated copy of a record or report of a government agency, domestic or foreign, that the individual is missing, detained, dead, or alive is prima facie evidence. And purport means to convey, imply, profess outward, to have the appearance of being, so it looks like, but it isn't. And prima facie evidence is basically is good and sufficient unless rebutted. Well, I have a record that says certified copy of record of live birth, or certified copy of record of birth. And, it was from 5 years after I was born, so, yeah. It has a big gold seal on it. I think it's been authenticated. What may not be authenticated is when you get a certified copy of something. So you need to take the certified copy and get the certificate of authority for the person that certified it. So if it's the Register of Deeds office, let's say, right? Well, who would certify the Register of Deeds? The office. I think the Great Seal would. Okay, so anyways, these are the ways that they can say you're dead. Also, if there's an accident or disaster, such, you're being lost at sea right now, I put that in there. In Washington State, it says this: evidence of death or status. So basically, their 2 in Michigan's B reads exactly the same. Their 3 in Michigan C reads exactly the same. And then, but they have a 5. And individual whose death is not established under this section, who is absent for a continuous period of 7 years, during which he or she has not been heard from, and whose absence is not satisfactorily explained after diligent search or inquiry, is presumed to be dead. That made you a decedent. So, if you're seen as a decedent, you need to appear. You need to appear in the proper court. Rich, some time ago, right, was told by a probate judge when questioned about this stuff, well, you need to petition, or you need to have an informal status hearing. And so they went down to try to do a petition, and we didn't know enough at the time, and it didn't work, right? But it doesn't mean that the judge lied to him. We just used the wrong form. So let's see what the Michigan petition form looks like. That is right here. So if you want to put a petition into probate, it's in the matter of. This could be a court case, right? It could be Robert Allen Radlewski, all caps, estate, right? Put the addition behind it. You got to put estate behind it. I am interested in this matter and make this petition as I'm the absolute owner. The interested person's addresses and representatives are identical to those appearing on the initial application petition. I think that's what the certificate of live birth is. It's the initial application. So I'm just following up on that one. And what's changed? Well, the addresses have changed, right? So now you would put your address down here. Well, my mother's still alive. I don't know if I changed her address or not. Or I don't know if she's changed her address in this. But yeah, I think you would. You just put down their new addresses. I state what? Well, I'm an estate that I claim the all rights, title, and interest. I state, that I've been considered deceased. I'm claiming all rights, title, and interest to my landed estate, Robert Allen Radlewski, all its accounts. And what do I request? I request that an inquest of office found to determine the rights, title, and interest, and an accounting made. And, me be put in charge of my estate. I just need to come up with the exact words, right? But I've already written them once or twice. I just need to go pull something off a piece of paper. But that's all there is to this. You put you down here. Or the petitioner right here. You don't need an attorney. Fuck him. Right? And then what are they going to do? They're going to check and put an order. Right? So we want to have an informal status hearing to determine that we're alive and that we have the rights, title, and interest to a particular estate, and to have an accounting of that estate, and have whatever debts need to be paid for the estate paid off, and the rest made available to our use. And then pick the status you want to be, right? So that's all there is. This one form right here, this is a petition and order form into probate. And you could use this for anything that had to do with you, because they're always going after your estate. And that's the exclusive jurisdiction of probate. Excellent. Okay. What else was there here? Well, this is just some interesting stuff out of Blackstone, right? If you go to Book 2, Chapter 7, you find this little quiz in there, riddle. Thus Gaius may be seized as a fee of a way leading over the land, of which Titus is seized in his demesne as of fee. Well, what does that mean? Thus Gaius, well, that's going to be them, may be seized as a fee, which means they don't have any dominion in the thing itself. What they have is a determinable fee till debt shall be paid, or until a minor shall attain the age of 21 years. Of a way is a method, scheme of management, leading means guidance, direction over the land, of which Titus, who is you, is seized in his demesne of the fee, which means the lands of a manor which the Lord retained to his own hands. All right, so what does all that mean? That they have no dominion, they own nothing, only a determinable fee under a scheme of management to control everything, guiding over the land of a manor which the Lord retained in his own hands, your body. Right? Until we show up, basically, and say that we're alive, they have this scheme set up where they control everything, including our bodies. They made us slaves. All right, right after that, in the same chapter, is this other one. This is really the Sesta KV Act here. The fee simple or inheritance of lands and tenements is generally vested and resides in some person or other, though the diverse inferior states may be carved of it, as if one grants a lease for 21 years, or 1 or 2 lives. The fee simple remains vested in him and his heirs. And after the determination of those years or lives, the land reverts to the grantor or his heirs, who shall hold it in fee simple again. All right, so you're going to have some property, you're going to lease it out for a lifetime, in common law is 20 years, right? So you can do it for up to 40 years altogether. However, the first one, for some reason, is 21 years. They say 20 and a year. Interesting. Anyways, yet sometimes the fee may be an abience. That is, as the word signifies, an exception, remembrance, contemplation of law, there being no person in existence in whom can vest and abide, though the law considers it always potentially existing and ready to vest whenever the proper owner appears. Right? We need to go have an informal status hearing. What does all that mean? The fee simple of inheritance of lands, tenements generally vested resides in you, though diverse inferior states may be carved of it. A drop of blood on a piece of paper, every time you sign your name on something, who knows, right? First of all, you have an inheritance in your body. That is your only private property. Everything else is public, but you can have ownership rights to it. But your private property is your body. And they took a drop of blood and they put it on a piece of paper and put an all capital letter name on it. And they called it land because it has your soil on it. And that became your landed estate. Some people think they took your baby's weight in gold and put it into an account. Somehow we have these prepaid accounts. Who did that? Who prepaid the accounts? What's that all about? I think the church did it. I think they're the ones who funded your estate. And we just never claimed it. And when we do, we're going to thank God they did it for us. Yeah, sometimes a fee may be an abience. And what does abience mean? Is a state of expectancy in respect to property, titles, or office, when the right to them is not vested in any one person, but awaits the appearance or determination of the true owner. Right? They're waiting for us to step forward, say we're the absolute owner, the true owner. Whatever. Bring in the records. Let's see if there's any liens against it. Let's clean this mess up. Okay, and then in Google, under deposit of title deeds, this is interesting because, this has to do with everybody's real estate. I'm going after my body, but some people want to go after their house. But still, there's a title deed against your body. It's a closed letter patent, closed up like a closed court roll. It's got your name on the outside. It's private. It's for you only, compared to an open letter patent, which is like public property, which is like your house, where anybody can go look at it. These other title deeds, the ones that got your footprints on it, right? That's the title deed to your property, and your father is at the top of the piece of paper as the sovereign, giving this land to you from the union of the two estates of your mother and father. Okay. What do we got? A method of pledging real property as a security for a loan by placing the title deeds of the lands in keeping of the lender as pledgee. Okay, so an equitable mortgage can arise in two different ways, either as a legal mortgage, which is never perfected by conveying the underlying assets, or by specifically creating a mortgage as an equitable mortgage. a mortgage over an equitable right, such as beneficiary interest under a trust, it will necessarily exist in equity only in any event. So these mortgages only exist in equity, they don't exist in law. This is what they're doing to us when with the title deed, right? We put the title deed to the house on a deed of trust and gave it to the bank as a security, as collateral. Under the laws of some jurisdictions, a mere deposit of title deeds can give rise to an equitable mortgage. Again, whoever holds the frickin' piece of paper is the owner. Right? They hold the legal title. That just gave them an equitable mortgage over the property. With respect to land, this has now been abolished in England. Okay, although in many jurisdictions, company shares can still be mortgaged by deposit of share certificates in this manner. Yeah, they're talking about the value of your estate. Equitable mortgages don't fit the criteria for legal mortgage, but are considered mortgages under equity in interest and justice because the money was lent and security was promised. Okay, so they're using equity against us, but they didn't come with clean hands because they didn't lend any money. They say they do. Read your deed of trust. It says for a loan, whatever, you're going to give these payments and put this stuff up as collateral. Well, show me the loan. Because all those things are only collateral. They're securities until the loan's been paid. Show me the loan. Show me that you lent me any money. But at the end of the day, they can't because they never signed the deed of trust. So there was never a contract. This could arise because of procedural or paperwork issues. Right? So up here they talked about things that hadn't been perfected. Right? So this could arise because of procedural or paperwork. Based on this definition, there are numerous situations which could lead to an equitable mortgage. When the borrower deposits title deed with the lender, it has historically created an equitable mortgage in England. But the creation of equitable mortgage by such process has been less certain in the United States. So it's this is the way it's done in England. Apparently, and you end up with a memorandum of deposit of title deed. This document is an undertaking by the borrower that he or she deposited title documents with the bank with his own wish and will in order to secure the financing obtained from the bank. All right, so you need to see if you're in the UK or someplace if you signed a piece of paper called a memorandum of deposit of title deed. Because if you did, it was with your own wish and will to give it to them. But they were supposed to have lent you some money and they didn't do it. Equitable mortgage, a deposit title deeds by an owner of an estate with a person from whom he has borrowed money with an accompanying agreement to execute a regular mortgage or by mere deposit or by the mere deposit just by giving it to them without even any verbal agreement respecting a regular security. Just because you gave them the piece of paper, it gave them an equitable mortgage over your property. So what we did here in the States, they were talking about this, what do you call it here? Memorandum of deposit of title deed. They still do this in India a lot, because if you put that in, you'll find in India they use memorandums of deposit title deeds. But it says here in the United States, we went to the Uniform Commercial Code. And I'm not going to read this whole thing, but many judges thought there was something inherently wrong with allowing a person, either out of desperation or foolishness, to summarily encumber all his personal property as collateral for a loan. Right? You put up all this personal property, you gave them your all capital letter name, and you gave them the title deed to the house for a loan that we don't even know that they gave us because they never signed the damn deed of trust. So we're going to subpoena them and say, well, okay, if you say you gave me a loan, bring it in and show it to me. The law of security interest is clear, as simple as possible. Well, that's interesting. Therefore, because of the very history of security interests demonstrated that judicial resistance to enforcing broad security interests would not stop debtors from trying to give them as inducement to creditors to extend financing, the better choice was to make the law of security interest as clear and simple as possible. The result was Article 9, which regulates interest security personal property as opposed to real. and establish unified concept of security interest as a right in the debtor's property that secures payments or the performance of an obligation. Okay, so they get an interest in our property until we perform an obligation or pay the loan. Under Article I, a security interest is created by a security agreement as which the debtor grants security interest in the debtor's property as collateral for a loan or other obligation. Okay, again, for a loan or other obligation. But they didn't sign the agreement. The security interest rights grants the holder the right to take remedial action with respect to property upon occurrence of certain events, such as non-payment of a loan. The creditor may take possession of such property in satisfaction of the underlying obligation. The underlying obligation. What is the security instrument supporting? Or actually, what's the underlying obligation supporting the deed of trust or the security instrument? The holder will set such property at public. The holder will sell such property at public auction or through private sale and apply the proceeds to satisfy the underlying obligation. If the proceeds exceed the amount of an underlying obligation, the debtor is entitled to the excess. This is bankruptcy, right? You go into bankruptcy, they're supposed to pay the underlying obligation and give you whatever was left. They didn't do that because nobody's ever lent you any money. All they have are these pieces of paper with just your signature on it. But because they have it in their file instead of you having it, well, they're the legal title holder. And because you didn't say, well, you didn't sign the contract, they're going to say that it was a gift. And they're going to make you morally liable for it. The security interest is typically granted by a security agreement. The security interest is established with respect to the property. If the debtor has an ownership interest in the property and the holder of the security interest conferred value to the debtor, such as giving a loan. Okay, so it's typically granted by a security agreement, and it takes more than one person to have an agreement. All right, both parties must agree. They need to sign the damn deed of trust. But if they do, the security instrument is established with respect to the property. If the debtor has an ownership interest in the property and the holder of the security instrument conferred value to the debtor, such as by giving a loan, they haven't done that. The holder may perfect the security interest to put third parties on notice thereof. Perfection is typically achieved by filing a financial statement, a UCC-1, with the government. Perfection can also be attained by possession of the collateral, which is the deed of trust, if the collateral is tangible property. Well, I think it's a piece of paper, right? And you gave them a promissory note, and you're giving them the title deed. You gave them all the frickin' tangible property. Absent perfection, the holder of the security interest may have difficulty enforcing his rights and collateral with regard to third parties, including a trustee in bankruptcy or other creditors who claim security interest in the same collateral. Whoever holds the piece of paper is the legal owner. They're holding the deed of trust. Doesn't matter they didn't sign it. Security interest in real property continue to be governed by non-uniform laws, such as statutory, case law, or both, which vary dramatically from state to state. In a slight majority of states, the deed of trust is the primary instrument. So a deed of trust is the primary instrument for taking security interest in real property, while a mortgage is used in the remainder. So if they're using a deed of trust, it's the primary instrument for taking a security interest in real property, not personal property. And personal property, but also for real property. So, alright, well, I know it's a lot of different little pieces of stuff, but I just real quick wanted to show you. These are different kinds of petitions that can be put into probate. Where are some good ones? Petition for settlement of personal injury claim, writ of garnishment, attachment, or execution. Petition for temporary restraining order. You could put a restraining order against the police to tell them to leave you alone. right? Either show you that you broke a law or quit coming to my house. If you have a warrant out for your arrest, what are you going to do? Well, go put in a petition for a restraining order until somebody comes in under oath and says that you broke the law, because that ain't happened yet. Petition and orders, $20. Issuance of a commission to take testimony costs $7. Right? To get people together to bring in the defendant and take his testimony. Oh, okay. So all sorts of to get an account. For each account filed, $20. I got one account. So very cool. We'll look at that's it about as far as I can go on trying to convince people. Go to probate. Do it in equity. Use the maximum of equity to your advantage. They're coming at you many times in equity, and by doing so, they have to have had clean hands, and they don't. So we're going to put in a subpoena to call them in as a witness and make them put their claim under oath. They haven't done that yet. And, I just suggest if you got a little time, go look at your state statutes. Put in subpoena, put in equity, put in chancery. Things like that. I mean, in Michigan, we're not even supposed to have courts of chancery, yet there's 60-some hits about courts of chancery in England. They still exist. And the probate court has exclusive jurisdiction over trust and estate matters. And I'm going to leave it at that and go see what I can do at probate. With a subpoena in equity, or asking for an inquest of office found to determine the rights, title, and interest in my land and estate. It's a great day. You all have a good day now. See ya.